Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, if you're enjoying our content, please remember to subscribe and hit the notification bell. It helps the channel grow. For today's live stream, we are going to be doing a deep dive in an opinion that was rendered by the U.S. Supreme Court this morning relating to the Computer Fraud and Abuse Act. This is the case of Van Buren versus the United States that came out this morning, and we're going to read the entire thing, including the dissent, because I want to make sure I understand it completely, and I also want to make sure to understand my own position better, because right now, I don't know the answer. I kind of sped read both, and I'm not sure where I sit right now. So that's interesting for me. Also, the split in terms of the vote was really interesting. It was 6-3, but it was a very weird 6-3. This was written by Amy Coney Barrett. I think this is the first substantive decision she has authored. She might have as a majority opinion. She's authored some other stuff and some dissents, I think, but this might be her first real substantive opinion in her term as Supreme Court officer, unless I'm mistaken, or Supreme Court Justice, I should say. So it was written by Amy Coney Barrett, was joined by my boy Gorsuch, Kavanaugh, and then the other three are Breyer, Kagan, and Sotomayor, which means that in dissent we've got Chief Justice Roberts, Alito, and Thomas. So we've got a bit of a split there. We've got the conservatives are split. We got 3 conservatives writing in the majority and 3 conservatives writing in dissent, with the 3 left people all in the majority opinion. So we're going to try to figure this out, and we're going to try to make sure if I understand it, try to figure out what I think the answer is. So we're going to be here for a little bit now, so get comfortable, and let's get started with this. Nathan Van Buren, a former police sergeant, ran a license plate search in a law enforcement computer database in exchange for money. Van Buren's conduct plainly flouted his department's policy, which authorized him to obtain database information only for law enforcement purposes. We must decide whether Van Buren also violated the Computer Fraud and Abuse Act. So does his retrieval of information from his police laptop in his police cruiser, where he's conducting a name search, and he's not doing it for official purposes, he's doing it for money, so he's selling access, basically. So that might violate department policy, and certainly does, but does it also violate the Computer Fraud and Abuse Act? That's the question of the moment. Here's what the Computer Fraud and Abuse Act makes illegal. It makes illegal to access a computer, and computer has a definition in the statute that includes hard drives and components as well, and databases and such like that. So the term computer here has a wider definition than you might initially think. To access a computer with authorization and to use access to obtain or alter information in the computer that the accessor, and this is the critical language, is not entitled so to obtain or alter. What does it mean that the accessor is not entitled to obtain? And also there's going to be a very lengthy discussion about what the word so means. I'm not making that up. So the Supreme Court concludes that he does not violate the Computer Fraud and Abuse Act, which is good for everyone's liability, but whether or not that's in keeping with the statute, we'll figure out. The Supreme Court continues in its sort of conclusion. This provision covers those who obtain information from particular areas in computers, such as files, folders, or databases to which their computer access does not extend. It does not cover those who have improper motives for obtaining information that's otherwise available to them. So the Supreme Court seems to be saying, at least in its conclusory statements, that you only violate the Computer Fraud and Abuse Act if you gain access to files, folders, and databases you couldn't otherwise gain access to. As long as you could gain access to them, then your motives are irrelevant. So it's not enough to merely violate a policy or violate a terms of use. You need to actually, if not hack into it, otherwise obtain it through some sort of surreptitious means. Seems to be the end conclusion, at least. Technological advances at the dawn of the 1980s brought computers to schools, homes, and offices around the nation. But as public and private sectors harnessed the power of computers for improvement, so-called hackers hatched ways to co-opt computers for illegal ends. After a series of highly publicized hackings captured the public attention, it became clear that traditional theft and trespass statutes were ill-suited to this because it didn't deprive owners of the property in a traditional sense. Congress, following the lead of several states, responded by enacting the first federal law as part of the Comprehensive Crime Control Act. A few years later, Congress passed the Computer Fraud and Abuse Act, which includes the provision at issue in this case. The act subjects to criminal liability anyone who intentionally accesses a computer without authorization or exceeds authorized access. What does exceed authorized access is going to be very important here. And thereby obtains computer information. The statute goes on to define the term exceeds authorized access to access a computer with authorization and to use such access to obtain or alter information in the computer that the accessor is not entitled to so obtain or alter. So what exactly does that mean? Does it mean that you have some permission to access the computer, but you're hacking into parts? Or does it mean that the person who's allowing you to do this is telling you, okay, whatever you do, don't look at this file or don't look at this directory? What exactly does that mean? Initially, subsection A2's prohibition barring access to only certain financial information. It has since been expanded to cover any information from any computer used or affecting interstate commerce, which is all of them. And then the people who violate this face some fairly serious criminal penalties. This case stems from Van Buren's time as a police sergeant in Georgia. In the course of his duties, Van Buren crossed paths with a man named Andrew Albo. The deputy chief of Van Buren's department considered Albo to be very volatile and warned officers in the department to deal with him carefully. Notwithstanding the warning, Van Buren developed a friendly relationship with Albo, or so Van Buren thought when he went to Albo to ask for a personal loan. Unbeknownst to Van Buren, Albo secretly recorded the request and took it to the local sheriff's office, where he complained that Van Buren sought to shake him down for cash. So we've got a person of potential local note here who is known to the police in some way. Chief of police says, probably don't want to hang around that guy, just FYI. And Van Buren here decides, I want to become his best friend, which is a perfectly legal thing to do. But, you were warned that there might be problems. So he recorded the conversation and he said, well, he's trying to shake me down, which doesn't appear to be true. So maybe that's why not to hang around him in the first place, right? The taped conversation, however, made its way to the FBI, as presumably they were investigating whether or not this really was a shakedown or not. So they eventually determined it wasn't a shakedown at some point, but the FBI wanted to devise an operation to see how far Van Buren would go for money. So he says, I need money, right? I'm a cop, I need money. And the FBI, being a smart FBI, says, wait a second. If this cop needs money and is going to random people in the street to ask for money, maybe he'd be willing to sell people out for money. Maybe his financial incentives will corrupt his judgment. So let's figure out if that's true. All right. So the FBI over here came up with a plan. The steps were straightforward. Albo would ask Van Buren to search the state law enforcement database for a license plate. So the FBI has now recruited unstable Albo as a confidential informant. Great. Albo would ask Van Buren to search the state law enforcement database for a license plate purportedly belonging to a woman who Albo had met at a local strip club. So Albo was going to go to Van Buren and say, I met this girl at a strip club. Please search the database about her for me. Albo, no stranger to legal troubles, would tell Van Buren that he wanted to ensure the woman was not, in fact, an undercover officer. In response, Albo offered him $5,000. All right. So we got Albo over here, who is now working for the FBI, who's going to go to Van Buren and says, I met a stripper. I want to make sure that she's at least legally clean. I'm going to give you $5,000. Van Buren said yes. Okay, that could be a problem. Things went according to plan. Van Buren used his patrol car computer to access the law enforcement database with his credentials. He searched the database for a license plate that Albo had provided. After obtaining the FBI-created license plate entry, so the license plate entry was fake, Van Buren told Albo that he had information to share, who then told the FBI. The federal government then charged Van Buren with a felony, a violation of the Computer Fraud and Abuse Act, on the ground he was running a license plate for Albo that exceeded his authorized access. The trial court showed that Van Buren had been trained not to use law enforcement database for an improper purpose, which was also defined as any personal use. Van Buren therefore knew the search breached department policy. According to the government, that violation of policy also violated the Computer Fraud and Abuse Act. So this is the sort of tension that has been circulating for a long time relating to the Computer Fraud and Abuse Act. In order to violate the Computer Fraud and Abuse Act, do you have to circumvent technological measures? So you have to hack in using a password you never had in the first place, or you have to somehow escalate your own permissions with the password you have in some way to give yourself access you didn't have, or access a database that you're not supposed to be able to access with those credentials. So is it overcoming technological or overcoming other sort of impediments of that kind of variety? Or everyone thinks it definitely includes that. This question is, does it include violating terms of service? Does it include going beyond the permissions that you've been given, not in terms of what you can access, but in terms of what you've been told you can do with it? It's not your property after all. And so you've been said, well, it would be the rough equivalent, although analogies break down at every level, right? It'd be the rough equivalent of you saying to a neighbor, I'm going to give you a key to my house in order to check on my dog. And he has access to your house to check on the dog, but while also in the house, he does other things beyond checking on the dog. So the question might be, in this analogy, would that be trespass because he exceeded your authorization, even though he had permission to enter? He did it for other reasons, like having a house party there or something. So that would be the rough equivalent in the real world, I guess. Consistent with that position, the government told the jury that Van Buren's access to the database for a non-law enforcement purpose violated the Computer Fraud Abuse Act's concept against using a computer network in a way contrary to what your job or policy prohibits, which is a tenable position at the time. The jury convicted. Van Buren appeals, arguing that exceeds authorized access clause applies only to those who obtain information to which their computer access does not extend, not those who misuse access. So in the house example, I have a key for your door, so I might misuse it, but that's not trespass or something like that. While several circuits see the clause Van Buren's way, the 11th Circuit is among those who have taken a broader view. Consistent with the circuit precedent, the panel held that Van Buren violated the Computer Fraud Abuse Act by accessing law enforcement database for an improper reason. And then there's a note here that Van Buren was also charged with and convicted of an honest services wire fraud. In a separate holding not at issue here, the United States Court of Appeals for 11th Circuit vacated the honest services fraud convictions contrary to a decision from the U.S. Supreme Court in McDonald versus United States. I don't know what that says off the top of my head, but he was charged with other things, and those other charges are falling through for a U.S. Supreme Court. So it's 2 times he's being saved by the U.S. Supreme Court, I guess. Both Van Buren and the government raised a host of policy arguments to support their respective interpretations, which is not what the Supreme Court's favorite thing to do is. Not to do policy. They like to do other things first. What we start with what we always do, the text of the statute. It's a good place to start. Here, the most relevant text is the phrase exceeds authorized access, which means to access a computer with authorization, and to use such access to obtain information in the computer that access is not entitled to obtain. I'm trying to remember the honest fraud wire fraud thing. I think it's because he never used the wire for the fraud, right? It's not really fraud because he's not defrauding anybody. So I think that's why it broke down, because it's not really fraud. He's doing what he said he'd do, so it's not fraudulent. So wire fraud's not obvious. Honest services violation seems obvious. Wire fraud less so. The parties agree that Van Buren accessed a computer with authorization when he used his patrol computer and valid credentials. They also agree Van Buren obtained information in the computer when he acquired the license plate record for Albo. The dispute is whether Van Buren was entitled so to obtain the record. Entitled means to give a title, right, or claim to something. The parties agree that Van Buren has been given the right to acquire license plate information. That is, he's entitled to obtain it from law enforcement databases. But was Van Buren entitled so to obtain? So is this word so a modifier of some way? Van Buren says yes. He notes that so, as used in the statute, serves as a term of reference that recalls the same manner as been stated or the way and manner described Black Law Dictionary. The disputed phrase entitled so to obtain thus asks whether one has the right, in the same manner as already been stated, to obtain the relevant information. And the only matter of obtaining information already stated is the definitional proposition via a computer one is authorized to access. Putting that together, Van Buren contends the disputed phrase is not entitled so to obtain plainly refers to information that one is not allowed to obtain by using a computer that he's authorized to access. On this reading, if a person has access to information stored in a computer, for example, folder Y, from which the person could permissibly pull information, then he does not violate the Computer Fraud Abuse Act by obtaining such information, regardless of whether he pulled the information for some prohibited purpose. But if the information is instead located in prohibited folder X, to which the person lacks access, he violates the CFAA. So he's going for more of the technological only aspect of this. The government agrees the statute uses so in the word's term of reference sense, but argues that so sweeps more broadly. It reads the phrase is not entitled so to obtain to refer to the information one was not allowed to obtain in the particular matter or circumstances in which he obtained it. So it might matter the exact way you're doing it, according to the government. The matter or circumstances in which one has a right to obtain information, the government says, are defined by any specially and explicitly communicated limits on one's rights to access information. As the government see it, an employee might lawfully pull information from folder Y in the morning for a permissible purpose, say to prepare for a business meeting, but unlawfully pull the same information from folder Y in the afternoon for a prohibited purpose. So the same exact activity might be legal or illegal, depending on, for example, your intent of what you're going to do with it, or maybe your motive behind it, or something like that. The government's interpretation has a surface appeal, but proves to be a sleight of hand. While highlighting that so refers to a manner or circumstance, the government simultaneously ignores the definition's further instruction that such manner or circumstances already will have been stated, asserted, or described. Under the government's approach to relevant circumstance, the one rendering a person's conduct illegal is not identified earlier in the statute. Instead, so captures any circumstance-based limit appearing anywhere, in the United States Code, a state statute, private agreement, or anywhere else. And while the government tries to cabin its interpretation by suggesting that any such limit must be specifically and explicitly stated, express and inherent in the authorization itself, the government does not identify any textual basis for this guardrail, which is perfectly reasonable. So if they're going to say, well, it means violating any permissions you had, not only in terms of the technological permissions, but in terms of what the person said you could do with it. So again, going to a real world example of, I give you permission to drive my car, in order to go to the grocery store, or the Ferris Bueller Day Off example is probably even more pertinent, right? I give you the keys to my car for the purpose of valet parking my car in the garage, but what you do with it, decidedly not limited to that. So the question would be, the question is essentially, did you steal my car? Or something equivalent to that, right? So we're trying to analogize here. I gave you the keys, but you went well beyond your access. And I told you that. So are you on the hook for that criminally in some way? You might be on the hook for that criminally in the car example. I'm just trying to reason by analogy, right? Thank you for subscribing, Michael Hatch. That's very, very kind of you. Thank you for becoming a subscriber. Van Buren's account of the word so, namely that so references the previously stated matter or circumstance in the text, is more plausible than the government's. So is not a free-floating term that provides a hook for any limitation anywhere. It refers to a stated identifiable proposition from the preceding text. Indeed, so represents a word or phrase already employed, thereby avoiding the need for repetition. $5 super chat from Ricardo Ospinilla. Thank you very much. And I need to move the chat box up so we can see the stuff. He says, so if I'm reading this right, the ruling means we won't get a felony by breaking a click-wrap agreement. That seems to be the implication, but before you go that far, let's make sure that we're understanding it properly. So let's not leap to the end of the page on that one. I'll let you know maybe. Stefan Rieken says, okay, I just saw the information from 10 minutes ago, but did you yet consider how the information is otherwise available to the officer? What other means the officer have to obtain the information in the database? The same means that he did. So his means of accessing it didn't change, but he did it for an unauthorized purpose, which maybe made the access itself unauthorized, even though he had the password. Again, it would be the equivalent of me giving you the key to valet park my car, but I gave it to you to valet park my car. If you go do other things with my car, you have exceeded the authorization for which I gave you the key. And so is now, in some sense, unauthorized. So that's the idea. Stacks Matcher says, what sucks about the law? Seems like you don't know a specific thing until someone breaks the law. I don't think that's true, Stacks Macker. He may not have known he was breaking the law, but he knew he was doing something wrong. Right? It's like, he may not have known that there was a specific law out there dealing with this. But I'm going to go out on a limb, and I'm going to say that the average person of common intelligence, if they have permission to access their employer's database, even if it's a private person, and someone comes up to them and says, hey, how about you look this file up in your private database, and I'll give you $5,000 to do it. You know you're doing something wrong, right? Right? If one of your friends says, hey, will you just look at this file for me? It's inside your corporate database. I'll give you $5,000 to do it. You may not know exactly what law you're breaking, but surely you know you're doing something wrong, right? So I don't think the law's out there to trick you as much as you think it is. Now, there might be some set of circumstances under which this would not be true, but I'm pretty sure Van Buren here knew he was doing a bad. The fact that he's getting off on it, the fact that he's not going to be held guilty of it, but I think he had some clue in advance that this was probably not right. Cash for private information seems like a bad. We agreed with Van Buren. The phrase is not entitled to so obtain is best read to refer to information that a person is not entitled to obtain by using a computer he's authorized to access. And yet he could be sued or he'd have QY. Also, I'd buy that for $1. Yeah, he could be fired. He could be sued. He might be guilty of some other law somewhere else. So there might be other things, but I think most of the time, and there's certainly exceptions, but I think most of the time, you're not going to be guilty of breaking a law without knowing you're doing something wrong. That's the point where Jiminy Cricket's supposed to come on your shoulder and be like, this doesn't seem right. The government's primary counter-argument is that Van Buren reading renders the word so superfluous. Recall the definition. And so we're going to go back to the statute, which is always a good place to go. To access a computer with authorization and to use such access to obtain information in the computer, the accessor is not entitled so to obtain. presumably with that authorization. So access the computer with authorization, not entitled to so obtain with that authorization, which sounds technological. Although, according to the government, so adds nothing to the sentence if it refers solely to the earliest date and manner of obtaining the information through use of a computer one had accessed with authorization. What matters on Van Buren's reading, as the government sees it, is simply the person obtains information he's not entitled to obtain at any point could be made even if so were deleted. By contrast, the government insists, so makes a valuable contribution if it incorporates all the circumstance that might qualify a person's right to obtain. Because only its interpretation gives so much work to do, the government contends the rule against superfluity means the interpretation wins. The rule against superfluity means that a word is not superfluous. It's the idea that every word means something. So we try to avoid interpretations of statutes which would render a word or clause meaningless. We're like, they must have meant something by it. This canon, however, does not help the government because Van Buren's reading does not render so superfluous. As Van Buren points out, without so, the statute would allow individuals to use their right to obtain information in non-digital form as a defense to CFAA liability. Consider, for example, a person who downloads restricted personal files he is not entitled to obtain by using his computer. Such a person could argue he is entitled to obtain the information if he has the right to access the personal files through another method, for example, by requesting hard copies. Right, so the idea is, I hacked the computer, but I hacked the computer to get information I was entitled to, so it wouldn't be a problem. With the word so, however, the CFAA forecloses that theory of a defense. The statute is concerned with what a person does on the computer. It does not excuse hacking if the hacker could have done it legally. So yeah, that's what Van Buren says the word so means, which goes back to the with authorization, right? So just because you could have done it through some legal channel is not enough. The word so, by referring back to with authorization, means that if you exceed your authorization in a technological sense, even though you could have done it legally, this way is illegal, which makes perfect sense. There are legal ways to do things and illegal ways to do things, even if it reaches the same exact result. I can get to the same result two different ways, and one's legal and one's not legal. So it's yeah. If your doctor sells medical records on the dark web, he's definitely violating HIPAA, for sure. So there might be other issues in there, for sure. But he wouldn't be violating the CFAA, which is fair. And this guy himself might be violating other statutes, either state or federal. I think he got off on all his federal charges, but there might be state charges here, for all I know. So just because he's not guilty of this particular offense doesn't mean there's some other offense he's not guilty of. So this clarification is significant because it underscores that one kind of entitlement to use computer information counts, the right to access the information by using a computer. That can expand liability, as the above example shows, but narrows liability too. Without the word so, the statute could be read to incorporate all kinds of limitations on one's entitlement. The dissent takes this statute, illustrates why. So the dissent thinks that it's pretty much more expansive. And we'll get there eventually. While the dissent accepts Van Buren's definition of the word so, it would arrive at the government's result by way of the word entitled. So the dissent says, yes, the word so refers back, but it refers back to the authorization entitled, and you're not entitled. So therefore, it's still the same thing. Fair enough. One is entitled to do something, the dissent contends, only when proper grounds are in place. And again, the same exact thing might be legal and illegal, right? If I give you the keys to my car for one purpose, it might be legal if you do it for that purpose, illegal if it's done for some other purpose, potentially. William W says, I understand if they fight over the word access, but damn. Yeah, don't you love it that they're fighting over the word so? That's one of the things that makes the Laramie smile. It's like we're fighting over the word so. This is where it's kind of boiling down. Now we're going to fight over the word entitled for a while. That's good stuff. Question. I'm doing certain searches on a computer about certain disease or medication. All of a sudden I'm getting ads about those searches. Did the provider violate HIPAA? No. Because if you're doing searches on a computer, like a search engine, then no, because Google is not a protected... No, let me get this right. It's not a... What's the right word for it? It's not a covered entity. Yeah. The HIPAA only applies to covered entities. HIPAA does not apply to everybody. So HIPAA applies to covered entities, which are then defined in the statute. Hospitals, doctors, things like that. So if you're typing on a search engine, if you're giving medical information to a search engine, they're not violating HIPAA because they're not a covered entity. HIPAA doesn't apply to them. Yeah, it doesn't apply to them at all. They're not a covered entity, so it's no problem. Naughty One says, here's my question. Is this a matter of the DA mischarging the person and matter to grandstand? No, it's not, because up until this moment right now, there was a very serious question about which interpretation was right. So no, it was not inherently improper. There was very serious question about which interpretation was right. This was not in any way. So no, I don't think that's a problem. And there might have been other charges that might have been appropriate, but yeah. If you did Google searches with Lawrence said, but you're an employee of Google, would that make them a covered entity? No, because your employer is not a covered entity in any sense. Why would they be a covered entity? Your employer. It doesn't even make sense. They're not involved in the healthcare industry. All they do is they pay part of the insurance, or they pay part of the premiums as part of a benefit. But they're not the insurance company, they're not the doctor, they're not the hospital. Why would your employer be a covered entity? If you share medical information with your employer, and your employer can ask for anything they want because, they're a private party. So HIPAA is because you always have permission to disclose your own health information to anybody you want. You yourself can't violate HIPAA regarding your own medical records. That doesn't even make sense. So you can give your medical records to anybody you want. So if your employer says, give me your medical records or I'm going to fire you, unless you can somehow squeeze it into an American with Disabilities Act complaint, if they do it for everybody, it would be very helpful if they do it for everybody. It would also be helpful if they had some legitimate business reason. But if they do it for everybody, then sure, why not? Because they're not a covered entity. Why would they be? If your employer self-insures, no, because even then they're paying all they're doing is they're paying the insurance company. Unless you're saying that they are unless you're saying that this private company doesn't, instead of using a health insurance company, is deciding to insure its workers by it itself insuring its workers through its own money, which sounds like a horrific plan. So if there's an employer out there who says, okay, we're going to get rid of all that pesky insurance stuff, and instead what we're going to do is we're going to pay for all the medical needs of all of our employees using our own money. So if you mean self-insurance in that way, first of all, that sounds like something no one would ever do. And second of all, I'm pretty sure they are still not a covered entity, because the definition of covered entities is in the statute. I don't think that works. But yeah. Yeah, my company does that, but it's administered by an insurance company, which means that they pay the insurance company, right? So, yeah, no. Deciding whether a person was entitled to obtain information, the dissent continues, therefore demands circumstances dependent analysis of whether access was proper. Self-insurance used to be common for companies. Well, it's not common now, so I'm going to go with no. The dental list gives me $5 and said, English is filled with combinations of words that only have meaning combined like a turn of phrase. How does every word have a meaning applied? Every word has to have meaning. That doesn't mean that it necessarily has meaning independent. So, but it must have the idea, at least, the preference. The preference for lawyers, the preference for judges is we want to give every word of a statute, every word of a contract, every word some meaning. Like, you wrote the word to mean something, presumably, right? Why else would you write it down? Presumably you meant something when you wrote the word down on paper. Or else, why did you write it down? Right? The very fact you wrote it down, you must have meant something by it. So if someone comes up with an interpretation and says, well, this word is meaningless or superfluous is another way to put it. This word is meaningless, superfluous, because if you took this word out, it would mean exactly the same thing. That is a disfavored interpretation in law. It's possible, it happens, but it is disfavored. Because the law, and here's the biggest legal fiction of all, you ready for this? The law, especially the courts, work under the premise that the legislature is smart. Despite all available evidence to the contrary, including, many overruling of statutes. But the justice system or the judicial system is nothing if not eternally hopeful. So they're eternally hopeful that Congress knows what it's doing. And when they wrote something, they meant something by it. So we're going to keep on with that premise, man. We're keeping the faith. Congress is smart. They know what they're doing. They wrote those words for a reason, damn it. We're going to figure it out. Yeah. The dissent's approach to the word entitled fares fine in the abstract, but poorly in context. The statute does not refer to information that the accessor is not entitled to obtain. It refers to information the accessor is not entitled to obtain. The word entitled, then, does not stand alone. Excuse me. Inviting the reader to consider the full scope of the accessor's entitlement to the information. The modifying phrase "so to obtain" directs the reader to consider a specific limitation on the accessor's entitlement. His entitlement to obtain the information in a manner previously stated. As already explained, in a manner previously stated is using a computer one is authorized to access. Thus, while giving lip service to Van Buren's reading of "so," the dissent, like the government, declines to give "so" any limiting function. The dissent cannot have it both ways. The consequence of accepting Van Buren's reading of "so" is the narrowed scope of entitled. The consequence of accepting his reading is the narrowed scope of entitled. So, okay. Not entitled "so to obtain." So to obtain is modifying the word entitled. So to obtain modifies the nature of entitled, so it limits the understanding of the word entitled. It doesn't render it irrelevant, it modifies it, which is perfectly fine, right? Because the word entitled might mean something by itself, but so to obtain adds color. Adds color to the word entitled to change its meaning. Now entitled means something else. I buy it, it works for me. I'm still not sure this is the best interpretation, incidentally. I still haven't picked a team. Because I think the dissent has some points, but it's making sense in my head. So it's not one of those cases where I read it, I'm like, this doesn't make any sense to me, or either this doesn't make any sense, or this is clearly right? I haven't gotten to that position. I'm in the neutral position of, it's all right. It's all right. I'll let you know if it's brilliant or dumb later. The government falls back on what it describes as the common parlance meaning of the phrase exceeds authorized access. According to the government, Any ordinary speaker of the English language would think that Van Buren exceeded his authorized access to the law enforcement database when he obtained license plate information. I don't know if going to an ordinary speaker of the English language is necessarily the right way to go here. The dissent, for its part, asserts this point settles the case. If the phrase exceeds authorized access were all we had to go on, the government and dissent might have a point. But both breeze, they're using the word breeze as a verb. So I was confused because I was like, breeze is a noun. In this context, it's a verb. Okay. But both breeze, by the CFAA's explicit definition of the phrase, exceeds authorized access. When a statute includes an express definition of a term, we follow that definition, even if it means varying from a term's ordinary meaning. If Congress gives something a term definition, that's what it means. This sounds suspiciously familiar. This sounds suspiciously familiar to a debate I was having recently on Reddit about Congress sometimes defines words. Uncivil law. Do you really think the government redefines words? What kind of naive belief is that? A naive belief held by the U.S. Supreme Court, so suck it. So the relevant question is not whether Van Buren exceeded his authorized access, but whether he exceeded his authorized access as the CFAA defines the phrase. Fair enough. It's not whether he exceeded authorized access in some abstract sense, but whether as the CFAA defines it because it's a defined term. As we've already explained, the statute's definition favors Van Buren's reading. That reading, moreover, is perfectly consistent with the way an appropriately informed speaker of the language would understand the meaning of exceeds authorized access. Andrew Scott becomes a member of the channel. Thank you for becomes a subscriber. Thank you for hitting that subscribe button, Andrew Scott. You can be like Andrew too and hit that subscribe button and hit that notification bell. It is always appreciated. Thank you for becoming yet another subscriber of the channel. It is really, really appreciated. Thank you. The reading, moreover, is perfectly consistent with the way that an appropriately informed speaker of the language would understand the meaning of exceeds authorized access. When interpreting statutes, court take note of terms that carry technical meanings. Now let's have an argument about what the word access means for a while. Access is one such term, long carrying a well-established meaning in the computational sense, a meaning that matters when interpreting a statute about computers. So it's not just the word access generally, but specifically about computers. In the computing context, access references the act of entering a computer system itself, or a particular part of the computer system, such as files, folders, or databases. Thank you, Super Iron Bob, for promoting the channel. That is always appreciated. Thank you very much. And thank you, Stack Smasher, for the subscribe. That's awesome. The government and dissent's broader interpretation is neither the only possible nor even necessarily the most natural one. While the statute's language spells trouble for the government, a wider look at the statute's structures gives us even more reason for pause. The interplay between without authorization and exceeds authorized access clauses is particularly probative. What's happening? Oh, okay. $10 from Andrew E. Thank you, Andrew. 2 interesting CFAA cases involve alt-right hacker Weave and late hacktivist Aaron Swartz. Aaron Swartz's story is very, very sad. And whether Aaron Swartz would be proven right or wrong, we finally found out, I guess. Vague policies made exceeded authorized access unclear in both. This ruling seems to say no for each. That seems to be the tentative conclusion, but there's a footnote, and we haven't gotten the footnote, and the footnote's confusing. So everyone thinking, aha, I understand what this case means. I'm not sure I know what the case means. So if I don't know, I'm not sure if you know, but we'll figure it out together. That's why we're here. Why did I delete my Texas video? I didn't delete it. Hold on. Hold on. Did my video go away? Let's see. No, it's still there. It's still on my channel. It's 5 videos ago. It's still on my channel. The interplay between without authorization and exceeds authorized access clause is particularly probative. Those clauses specify 2 distinct ways of obtaining information unlawfully. First, an individual violates the provision when he accesses a computer without authorization. Second, an individual violates the provision when he exceeds authorized access by accessing a computer with authorization and then obtaining information he's not entitled so to obtain. The opinion's talking a little bit in circles. Smitshaw said, I thought recently you said laws don't use the dictionary as a source of definitions. They don't. We've been reading Congress's statute, the law that they passed, and they didn't use a definition. They provided their own. Now, the Supreme Court, in interpreting the law, sometimes uses definitions, which I said in that video, right? But I can't think of any statute or regulation that just cites a dictionary for a definition. Can't think of one. So, yeah, no law does, but when you're looking to understand words, courts sometimes look to dictionaries as a helper along the way, which I think I said the first time. So, Van Buren's reading places the provisional parts, in a harmonious whole. The government's does not. Start with Van Buren's view. The without authorization clause, Van Buren contends, protects computers themselves by targeting so-called hackers, those who access the computers without any permission at all. Van Buren reads the excess authorized access clause to provide complementary protection for certain information within computers. It does so, Van Buren asserts, by targeting so-called inside hackers, those who access the computer with permission but then exceed the parameters by entering an area of the computer to which that authorization does not extend. So it's the difference between an outside hacker and an inside hacker. That makes sense. Van Buren's account of subsection A2 makes sense of the statutory structure because it treats without authorization and exceeds authorized access clauses consistently. Under Van Buren's reading, liability under both clauses stems from a gates up or down inquiry. Okay, yeah. Is the gate up or the gate down? Right? If the gate is down and I breach the gate in some way, that's the problem. Okay. One either can or cannot access a computer system, and one either can or cannot access certain areas within the system. And there's a footnote here, footnote 8, which just creates all kinds of confusion. For present purposes, we need not address whether this inquiry turns only on technological limitations, or instead also looks to limits contained in contracts or policies. I don't understand this footnote in any way. I was listening to Hoglaw a little bit, and he didn't understand the footnote. And I have to share my fellow attorneys' confusion. You know, I was under the very strong impression that looking to limits contained in contracts or policies was in fact a major part of this very case, the one we're talking about right now. I was under the very distinct impression that Van Buren's police policies said, don't do this. So Amy Coney Barrett writes, for our present purposes, we need not address whether this inquiry is only technological in nature, or also looks to limits contained in contracts and policies. Like, for example, the one that's at issue in this very case. I don't understand this footnote. Richard Hogue didn't understand this footnote. Richard Hogue doesn't understand this footnote. I don't understand this footnote. This footnote doesn't make any sense. Isn't like everything we've been talking about up to this point pretty much technological in nature and not contractual or policy based? So, but you're undoing that all in a footnote. You're basically undoing the entire opinion in a footnote. So all you guys out there who are like, oh, I understand this case, I'm not sure you do. I'm not sure I do. I'm not sure Richard Hogue does either. I'm not sure. And Richard Hogue is a smart guy, man. And he can't figure it out. And I can't figure it out. I don't know what this footnote is doing. This footnote's just confusing the hell out of me. The footnote is, Min Do says, I hope I'm pronouncing this right. Min Do says, the footnote is saying the court isn't diving into whether the law only defines access in terms of ability or contractual permissions. Yes, I understand that, but why not? Because that's kind of the issue. That is the very issue at play here. Because no one argues that Van Buren did anything technical that was wrong. Nobody. He logged in with his computer using his password. He got access to the same database he uses every single day. He didn't somehow internally hack to escalate his permissions or something. He used the thing the same way he does 1,000 other times, and 1,000 other times he does it for perfectly lawful purposes. Right? So the 1,001st time, he does it for a prohibited reason. But he doesn't do anything technologically different. So the court's saying, well, we're not going to delve into whether or not contracts or policies influence the CFAA. It's like, why did you take this case? Why are you writing a decision right now? What the hell am I supposed to do with this? I don't know. It doesn't make any sense. Yes, Stefan Rieken has it right. This case is only about policy, not physical ability. Right. That's exactly right, Stephen. This case is only about policy. So, when you write in a footnote, for present purposes, we need not address whether the inquiry, which is whether or not one can access certain areas of a system. Okay. All right. I can square the footnote with, okay, I've got it. I'm not sure it makes much more sense than it did before, but I understand the footnote. Okay. I've got it. The footnote is talking about whether one can or cannot access the system, or one or cannot access certain areas within the system. That's the key. Okay. So that's the key, because he didn't access an area of the system that was in violation of policy. Right? So so she's saying, for present purposes, we don't need to decide whether the inquiry as to whether or not you can access the computer, whether or not you can access a certain area, it turns on technological limitations, or instead only looks to contracts or policies. So, okay, so the way to square this circle, and I'm not sure how much better it made it than when we started, but at least I understand it now, having thought about it a couple times to make it make sense in my head. Let's suppose, okay, so the idea is you have we'll make it simple, right? You have access to a series of file folders on a drive, right? So you have permission to access folder A for purposes related to your job, but you do not have permission to access folder B for any reason for your job. But you have access, but you're not permitted to access. So this would be the equivalent. This would be, if we're going to go to real world equivalents, right? If we're going to go to real world equivalents, it would be, I'm giving you, my assistant, the key to the file drawers, right? To the file drawers in my file folders. And I say, okay, this key will open all the drawers, right? It'll open the entire file cabinet, right? So I say, okay, I'm giving you this key, and for the purposes of your job, you can access, and this has 4 drawers in the file cabinet, right? And so for the purposes of your job, you can look at the top, the second from the top, and the third from the top, but not the very bottom. You cannot look at the very bottom folder. I only have one file cabinet, so I'm not going to separate those files into a separate place, but I'm going to tell you, you can't look at the bottommost file cabinet, right? All right. So the equivalent here is, I give you access to A. I give you access to the file, the cabinet 1, 2, and 3 for certain purposes, and accessing those in excess of the purposes, you access them. So that does not violate the policy. The violation would be if the credentials I give you would allow you, in this case, the credentials are the key. It's a token credential, if we want to be, if we want to be proper about this from like a information security proposition. A key is a token. So I've given you the token, which is the key, and I say you can never access the bottom folder, and you do. So that's what Amy Coney Barrett is writing about. So she's saying we don't have to decide if your password would allow you to access computer A and computer B, but you're forbidden from accessing computer B by policy. We don't have to decide if you can access folder A and folder B with your password, but you're forbidden from accessing folder B by policy. That's what she's writing about. I'm not sure it makes more sense. It really reconciles everything, because the question would be why the policy would allow a company, I guess because it's absolute, so there's no ambiguity, might be the idea, but so there's no confusion, so you can never do it. And maybe that's the reason why, because you have enough notice of what's criminal and not, because you can never do it under any circumstances. So it's not like I didn't understand. So there's not this middle ground of I can do it sometimes, but I can't do it other times. And maybe it's the idea. I'm sorry for talking through this at some length, but I have to explain it to myself. And that's what I'm doing right now, is I'm explaining it to myself. And to you, incidentally, at the same time. So the idea maybe is we don't want to create criminal liability for situations in which the nature of the violation of the policy is potentially ambiguous, because you might be able to do it without really noticing you're doing it. So it would be the equivalent, again, of like trespassing on land without really noticing you're doing it. And us not willing to say, okay, well, if it's ambiguous because you can do it sometimes and not. So it would not be a trespass for me to give, it would not be a trespass, I think, for me to give you the key for my house and for you to enter my house for exceeding permissions. I don't think that would be a trespass. But if I say don't ever, there's actually a very interesting story about this. I forget who wrote this story, but there's actually a very interesting story about this from a horror writer or something, and I think it's older horror. I don't think it's modern horror. But there was the story of there's the story of this guy, and I'm sure it's fictional. There's a story of a guy who marries. He's a very well-to-do guy, and he marries his new bride. And he says, "I'm going to give you keys. I'm going to give you keys to the entire mansion. You know, you can do whatever you want. You can go into any room you want. You can use anything you want, but you must never open this particular door, right? But I'm going to give you keys to the entire house. And so the wife, of course, so he says to her, I'm going to give you access to the whole house, but you must never enter this particular door, right? And the wife dutifully obeys. And then one time he's going out of town for a little while and says, okay, so now I'm going to leave you the keys in your sole possession, and you must not enter that particular door. And of course, what does the wife do? She eventually gives into temptation. She enters the door, and it turns out in this folk tale or this novel or whatever it is, turns out in this that it's, you know, the torture, it's the bind, torture, kill room, you know, with I think in this particular story, it's all his dead wives, all of his ex-dead wives who he murdered for breaking the rule, presumably. So it's filled with his deceased wives who he has killed. And she, in the story, what is it? The key or something gets stained with blood, and she can't get the stain off no matter what she does, or she gets like a stain of blood in her, or the key gets stained, or something is irreversibly changed, and no matter what she do, she can't fix it. And so the way the story comes back, goes, is the guy comes back from his vacation, and at first he doesn't even say anything. You know, he doesn't ask anything. He doesn't even ask for the keys back right away. But like the key is stained, right? So he doesn't even ask for anything. You know, he's not being abusive or anything. But at some point in the future, he says, you know, whatever happened to those keys? I need them back because I need to access a room, right? Presumably he's going into his BTK room or whatever. And she's like, oh, I lost him. It's like, okay, well, you know, let me know when you find him. And through the story or whatever, he finds it, and the key is stained with blood. And because it's stained with blood, he knows that she accessed the room, and then he kills her. And, you know, the story continues. Some version of that. Was it Bluebeard? Yeah, it was something like that. Anyways. No, this is definitely not Beauty and the Beast. It's much more hardcore than Beauty and the Beast. So that's the idea, I think. So we don't want the situation ambiguous, maybe, for the criminal liability. We want it to be absolutely black or white for the liability. So that's what she's talking about. Okay, now that I've sufficiently explained it to myself, we can move on. So I figured it out, and Richard Hogue didn't. Yay. And reading both clauses to adopt a gate up or gate down approach aligns with the computer context understanding the access entry. By contrast, the government's reading of exceeds authorized access clause creates inconsistencies with designs and structures of subsection A2. As discussed, the government reads exceeds authorized access clause to incorporate purpose-based limits contained in contracts and workplace policies. Yet the government does not read such limits into the threshold question of whether someone uses a computer without authorization, even though similar purpose restrictions, like a rule against personal use, often governs one's right to access the computer in the first place. William W. says, why did you hear a horror story from a case about computers? Because it was an analogy. And it was an analogy from some historical thing about absolute rules and what happens when you break absolute rules, and why, if you break an absolute rule, it might mean death, or in this case, maybe less with the death, but more with the 10 years in federal jail. The government does not explain why the statute would prohibit accessing computer information, but not the computer itself for an improper purpose. The government's position has another structural problem. Recall that violating A2, the provision under which Van Buren was charged, also gives rise to civil liability. Provisions defining damage and loss specify what a plaintiff in a civil suit can recover. Damage, the statute provides, means any impairment to the integrity or availability of the data, a program, a system, or information. The term loss likewise relates to costs caused by harm to computer data, program, system, or information systems. The statute defines damage and loss, thus focuses on technological harms, such as corruption of files, the type unauthorized users cause. Limiting damage and loss in this way makes sense in a scheme aimed at preventing the typical consequences of hacking. The term's definitions, however, are ill-fitted to remediating misuse of sensitive information that employees may permissibly access using their computers. Van Buren's situation is illustrative. His run of the license plate did not impair the integrity or availability of the data, nor did it otherwise harm the database itself. It's Edgar Allan Poe. There you go. Pivoting from text and structure, the government claims that precedent and statutory history supports its interpretation. The arguments are easily dispatched. As for precedent, the government asserts this court's decision in a prior case bolsters its reading. Therein addressing a question about standard of review for instructional error, the court described A2 as prohibiting obtaining access without authorization and obtaining access with authorization but then using that access improperly. That paraphrase of the statute doesn't do much for the government. As an initial matter, the prior case does not address, much less resolve, the government's favor, the point now at issue, and thus we're not bound to follow the dicta in any case. But in any event, Van Buren's interpretation, no less than the government's, involves one use of access improperly. It's plainly improper for one to use his opportunity his computer access provides to obtain prohibited information from within the computer. Yeah, Guru for Hire thinks, I think they're saying that you can't use the database for this purpose is not the same as you can't use this database. Right, that's what the footnote means. That's what footnote 8 means. As a footnote, so it's dicta. So we spent, but then again, it's dicta from the Supreme Court, and lower courts take that shit seriously. So we spent an inordinate amount of time trying to figure out what a footnote meant, and then we finally figured it out. So I feel very validated because I figured it out after some confusion. So it was good for me. According to the government, this confirms the amended CFAA, which makes no mention of purpose in defining exceeds authorized access, likewise covers insiders like Van Buren, who use their computer access for unauthorized purpose. You know, not for nothing, but I hope for the 108 of you who are watching that you appreciate what I'm trying to do, at least, by working through a problem and trying to figure out what this means so I can understand it, so I can explain it. I feel it doesn't lend itself to some of the pop of some people, but, you know, I really wanted to understand this, and so I figured I'd understand it with you. So hopefully some of you out there appreciate it. Please like the video. The government argument gets things precisely backwards. When Congress amends legislation, court must presume it intends the change to have real effect. Congress's choice to remove the statutory reference to purpose thus cuts against reading the statute to cover the concept. Statutory history thus hurts rather than helps the government's provision. To top it off, the government's interpretation of the statute would attach criminal penalties to a breathtaking amount of common computer activity. Van Buren frames the far-reaching consequences of the government's reading as triggering the rule of lenity, or constitutional avoidance. Not the worst idea I've ever heard of. The rule of lenity is a rule in criminal law particularly, which basically says any ambiguity in a criminal statute should go in favor of the defendant. It's basically a rule of leniency, right? That's not how we see it. Because this text, context, and structure supports Van Buren's reading, neither of these canons is in play. But if they were, it would break that way, so it's helpful. Still, the fallout underscores the implausibility of the government's interpretation. It's extra icing on a cake already frosted. Yeah, that's fair. If exceeds authorized access clause criminalizes every violation of a computer use policy, then millions of otherwise law-abiding citizens are criminals. Take the workplace. Employers commonly state that computers and electronic devices can be used only for business purposes. So on the government's reading of the statute, an employee who sends a personal email or reads the news using her work computer has violated the CFAA. Yeah. Or consider the internet. Many website services and databases which provide information from protected computers authorizes a user access of his agreement to follow specified terms. If If the exceeds authorized access clause encompasses violations of circumstances, access restrictions on employees' computers, it's difficult to see why it would not also encompass violations of restrictions on website providers' computers, which presumably would mean that if I upload a video that's in violation of YouTube's terms of service, not only can my account be canceled, but I can be put in jail for my video. So they're saying, maybe not so much with that. Stephen Rakin says then that's a bad argument. It's a bad argument. It's a bad argument. It's not the strongest argument. I'll agree with you. It's a weak argument. It's a weaker argument, but it is an argument that does flow. It's an argument against absurd consequences that are not clear. And it's saying, look, the statute is capable of a couple different meanings, and if we interpret this, it would lead to these kinds of results. And if we interpret this way, so I think this reading, and I'm still not sure, I still haven't picked a team, but this reading seems reasonable. The statute isn't like abundantly clear. I think you'd be hard pressed to say the statute clearly commands the opposite result. It's not clear exactly what it's talking about. And so the court's saying, look, if we read it this way, which is also, I think, a plausible reading, although maybe less, and we'll get to the dissent and see which one's more plausible. And maybe the dissent will convince me it's right. But if we read it this way, it would sweep in all kinds of conduct, and surely Congress would have been a little bit clearer if they meant that. So it's a weaker argument, but I think it's a reasonable one. It's not your go-to. If the statute's clear, right? In response to these points, the government posits that other terms in the statute, specifically authorization and use, may well serve to cabin its prosecutorial power. Yet the government stops far short of endorsing such limitations, nor does it cite any particular prior instance in which it's read the statute to contain these limitations. To the contrary, Van Buren cites instances where it hasn't. So the government says we could read it more limitedly, and Van Buren's like, yeah, but you never have. If anything, the government's current CFAA charging policy shows why Van Buren's concerns are far from hypothetical. The policy instructs federal prosecution may not be warranted, not that it would be prohibited, if the defendant exceeds access solely by violating an access restriction contained in a contractual agreement or term of service. And while the government insists the intent requirement serves as yet another safety valve, that requirement would do nothing for those who intentionally use their computers in a way that job or policy prohibits, for example, checking sports scores or paying bills at work. One final observation. The government's approach would inject arbitrariness into the assessment of criminal liability. The government concedes, as it must, that exceeds authorized access clause prohibits only unlawful information access, not downstream information abuse. So it would only go to the person who did the bad thing with the computer, not anyone who did something with the information after the fact. Although conspiracy law or accessory law might get you there, but whatever. But the line between the two can be thin on the government's reading. Because purpose-based limits on access are often designed with an eye towards misuse, they can be expressed as either access or use restrictions. For example, one police department might prohibit using a confidential database for non-law enforcement purposes, which would be an access restriction, while another might prohibit using information from the database for a non-law enforcement purpose, which is a use-based restriction. Conduct like Van Buren's can be characterized either way. An employer might not see much difference between the two. On the government's reading, however, the conduct would violate the CFAA only if the employer phrased the policy as an access restriction. An interpretation that strikes so much on a fine distinction controlled by drafting of private parties is a hard sell as the most plausible. In sum, an individual exceeds authorized access when he accesses a computer with authorization, but then obtains information located in particular areas of the computer, such as files, folders, or databases that are off limits. The parties agree that Van Buren's accessed the law enforcement database with authorization. The only question is whether Van Buren could use the system to retrieve the information. Both sides agree that he could. Therefore, it did not exceed authorized as the CFA defines the phrase. Okay, so All that sounds pretty plausible. It sounds pretty plausible to my ear. I could certainly be a buyer, but let's see if Justice Thomas can do a better job of selling me than Justice Barrett. So what does Justice Thomas have on offer? Both common law and statutory law have long punished those who exceed the scope of consent when using property that belongs to others. A valet, for example, may not take possession of a person's car, may take it for possession to park it, but cannot take it for a joyride. The Computer Fraud and Abuse Act extends that principle to computers and information. The Act prohibits exceeding the scope of consent when using a computer that belongs to another person. Specifically, it punishes anyone who intentionally accesses a computer without authorization or exceeds authorized access and thereby obtains information from the computer. As a police officer, Nathan Van Buren had permission to retrieve license plate information from a government database, but only for law enforcement purposes. Van Buren disregarded this limitation when, in exchange for several $1,000s, he used the database in an attempt to unmask a potential undercover officer. Well, I guess, yeah. The question here is straightforward. Would an ordinary reader of the English language understand Van Buren to have exceeded authorized access to the database when he used it under circumstances that were expressly forbidden? In my view, the answer is yes. The necessary precondition that permitted him to obtain the data was absent. The court does not dispute the phrase exceeds authorized access readily encompasses the conduct. It notes instead the statute includes a definition for the phrase, and we must follow that definition. The problem for the majority is that the text, ordinary principles of property law, I'm not sure about that, and statutory history established the definitional prohibitions quite consistent with the term it defines. I'm not sure that going to ordinary principles of property law is necessarily correct because this is not really in that context, obviously. The Act exceeds authorized access as to access a computer with authorization and use such access to obtain or alter information that the accessor is not entitled to obtain or alter. For the purposes of this appeal, it's agreed that Van Buren was authorized to log into the government database, and they used his entry to obtain fake license plate information from that database. I thus agree with the majority that this case turns on whether Van Buren was entitled so to obtain the fake license plate information. I also agree that so asks whether Van Buren had the right to obtain information through the means identified earlier in the definition, accessing a computer with authorization, and using that access to obtain information in the computer. In other words, Van Buren's conduct was legal only if it was entitled to obtain that specific license plate by using his admittedly authorized access to the database. $5 from the dentist, thank you very much. Wouldn't giving access to someone not even allowed to touch the computer be exceeding access in a technological sense? Sure, because it wouldn't be their password. Yeah. So that would exceed it technologically. Yeah. A person is entitled to do something only if he has the right to do it. Van Buren never had the right to use the computer to obtain that specific license plate information. Man, that's cutting it narrow, though. Everyone agrees that he obtained it for personal gain, not valid purpose. And without valid purpose, he was forbidden from using the computer to obtain that information. Maybe in this example, yes, but I'm interested how this extends to the parade of horribles of people violating terms of service that they may not be even aware that they're violating. Because, like, well, we have all clicked the button saying we read, understand, and agree to the terms, right? So we're on notice. And if we exceed that, so maybe this is cleaner than most, but I'm not sure how you cabin it, how you keep it to that context. The majority postulates an alternative reading of the definitional prohibition. So long as a person is entitled to use a computer to obtain information in even one circumstance, the statute does not apply even if the person obtains the data outside that circumstance. That's the majority's view. Yeah. If, in effect, the majority reads the statute to apply only when a person is not entitled under any possible circumstance to obtain information. Yeah, kind of. Foremost, that interpretation is contrary to the plain meaning of the text. Entitlements are necessarily circumstance dependent. A person is entitled to do something only when proper grounds or facts are in place. Focusing on the word so, the majority largely avoids analyzing the term entitled. Well, the majority thinks that this so actually kind of modifies entitled, concluding at the outset in a single sentence that Van Buren was entitled to obtain the license plate information. But the plain meaning of entitled compels the opposite conclusion. Because Van Buren lacked a valid purpose, the proper grounds did not exist, he was not entitled. A few real-world examples illustrate the point, and this is always the danger with analogies and reasoning by analogies, because all analogies eventually break down. And I gave some real-world analogies of where this would go the other way, but of course all analogies have their limitations, right? A few real-world scenarios illustrate the point. An employee who is entitled to pull an alarm in the event of fire is not entitled to pull it for some other purpose, such as delay a meeting. A valet who obtains a car, to borrow the language, is entitled to access the car and entitled to use it to park and retrieve it, but is not entitled to joyride the car. And then cites a specific example in Indiana, which knowingly or intentionally exerts unauthorized control over the property of another if it's a motor vehicle. And to take example closer to statute, employee of the car of a rental company may be entitled to access a computer showing a GPS location of a rental car and use such access to report it or locate it if stolen. But it'd be unnatural to say he's entitled to use such access to stalk his ex-girlfriend. The majority offers no real response. I don't think that's fair. I think they offer a response. You may not find it convincing, but I don't think I go so far as to say it's not a real response. It notes that entitled is modified by so, which it is, and the courts therefore must consider whether the person is entitled to use it to obtain information. But if a person is not entitled to obtain it at all, it necessarily follows that he has no right to access the information by using a computer. Yeah. Van Buren was not entitled to obtain the information at all because the condition precedent needed to trigger entitlement. Law enforcement purpose was absent. No, that's not quite right. He was entitled to obtain the information if it was pursuant to it. Yeah, so this is I don't agree with this conclusion. It's wrong, in my view, to say Van Buren was not entitled to obtain the information at all. He was, if he had a valid law enforcement purpose. Now, that would not have, as a practical matter, been possible, because there's no possible valid law enforcement purpose he had, because the entire information was fake in the first place. There is no license plate that he'd be reading. But at least theoretically he would, right? He would have a valid reason to look at it if he had a valid purpose. So there is a situation in which what he would be doing is valid. It's not this, but there's one that he would not be. It's not like he can't do it at all, So I don't think that quite follows, I don't think that conclusion quite follows for me. Next, the majority's reading is at odds with basic principles of property law, which it kind of is, but then again, property law is an imperfect analog, which is kind of the reason CFAA was created in the first place. By now, it's established that information contained in a computer is property. Sure, why not? Nobody doubts, for example, that a movie stored on a computer is property. Federal and state law routinely define property to include data. And even the majority acknowledges the statute is designed to protect property, yet fails to squarely interpret the familiar rule that entitlement to use another person's property is circumstance-specific. We've discussed this a little bit already, yes. Consider trespass. When a person is authorized to enter land and entitled to use the entry for one purpose, but does it for another, he trespasses. As the second restatement tort explains, a conditional or restricted consent to enter land creates a privilege to do so only insofar as a condition or restriction. So apparently my understanding of property law was slightly off. So if I give you a key to my house for the purposes of watching my dog, but you use the key to my house for the purpose of having a house party at my house, you're actually in trespass to my house. So, hey, who knew? I was slightly wrong. So we get smarter. The restatement includes a helpful illustration. Person A grants permission to person B, his neighbor, to enter A's land and draw water from A's spring for B's own use. A has specifically refused permission to C to enter the land. At C's insistence, B enters the land and obtains water for C. B's in trespass. Because B's doing it as an agent for C who doesn't have permission, so yeah, that makes sense. What is true for land is also true in the computer context. If a computer grants permission to an employee to use a computer for a specific purpose, the employee has no authority to use it for other purpose. Well, Ming Dao, I think you have to work on the LK. This is to Ming Dao. LK, you have to work on your hypothetical, because if he did it for a friend who stalked his girlfriend, stalking is illegal. So he would have a valid law enforcement purpose. So you might need to come up with a different hypothetical on that one. I understand what you're trying to do. Just, construct it a little bit better. Consider, too, the common understanding of theft. A person who is authorized to possess property for a limited purpose commits theft the moment he exerts unauthorized control, which occurs whenever consent or authority is exceeded. To again borrow the language from the statute, a police officer may have authority to access the department's bank account and use the access to cover law enforcement expenses, but he's nonetheless guilty of embezzlement if he uses it to line his pockets. Yeah, fair enough, but yeah. He would not be exonerated simply because he'd be entitled to obtain the funds under other circumstances. Right. Or take a bailment. This doesn't have anything to do with bail in the sense of like getting out of prison. A bail in this sense is basically entrusting someone with property. So when you give someone, give the valet your car, that's a bailment. So, yeah. Take a bailment. A bailee commits conversion, which many jurisdictions criminalize, when having no authority to use the thing bailed, the thing entrusted to him, nonetheless uses it, or having authority to use it, uses it differently. A computer technician may have authority to access a celebrity's computer to recover data, but not to use his access to copy and leak press photos stored on the computer. The majority makes no attempt to square its interpretation with the familiar principle. Well, I'm not sure that's true. I think they look at the statute and its wording, and their interpretation's plausible. And words matter in statutes, which I'm sure Thomas well knows. And these analogies break down, and they might break down at this point. So, Majority never identifies any particular property law buzzwords that thinks Congress was obligated to include. But that, I don't really like that sentence. It's kind of, it feels a little disingenuous to say the majority never identifies any buzzwords that things Congress was obliged to include in order to invoke property law. I feel is a little bit off, because we don't do law by magic words. So it's not like, well, geez, if you had used this word or this word or this word, it would necessarily cause us to go in a different place. But using certain words obviously has particular meanings. So it's not like, oh, there's particular buzzwords or even a set of them. But if you use particular words that invoke a particular context, obviously that context is invoked. So the majority doesn't identify those words explicitly, but you wouldn't expect them to. It's like, well, if the statute is obviously bereft of them, I think we can agree that much. It's not like the statute explicitly goes to property law or explicitly incorporates common law concepts of property or explicitly incorporates common law concept of trespass. So it's not doing that. So I don't really like this conclusion because it feels a little disingenuous somehow. The majority next says that relying on pre-existing concepts of property law is ill-advised because Congress enacted this law in light of failure of pre-existing law to capture crime. Yet the reasons why pre-existing law was considered inadequate undermine the majority's position. First, state laws were used to cover conduct like Van Buren's, but doing so required considerable creativity because those laws either required physical entry, which fit poorly with computers, or depriving a victim of property, which fit poorly when a person merely copied data. Second, the fit was even more awkward for federal laws, which were more limited in scope. Anyone remember when federal laws were limited? Congress did not enact this law to eliminate the established principle that entitlements to use property are circumstance-specific, but instead eliminate the deprivation and physical entry requirements. Well, that might have been what they were hoping to do, but they didn't really do that explicitly. You're reading in, this is also a little bit odd for Thomas. It's like you're reading in a purpose that's not obviously there, you know? Unable to square its interpretation with established principles of property law, which I'm not necessarily sure they're under a burden to do, because again, there's nothing in the statute that by its explicit terms invokes property law to me. Now, I can see you looking to property law as a guide, but to say that you have to seems unfair. The majority contends its interpretation is more harmonious with a separate clause in statute that forbids accessing a computer without authorization. And the majority is telling the clause requires a gate up or gate down inquiry. One either can or cannot access it. So it makes sense to read exceeds authorized access in the same sense to include the same approach. I agree the two clauses should be read harmoniously, but there's no reason to believe that if gates are up in a single instance, they must remain up indefinitely. Yeah, but the gate is up. That's the problem in Thomas's analogy. The gate is up. There's just a policy saying don't go through the gate. That's the difference here, right? If the gate were down, then that would be one thing, but the gate's not down, the gate's up, and simply a policy saying don't go through the gate. An employee who works with sensitive defense information may generally have authority to log into his employer's issued laptop, but the employer instructs him not to log on while in a country where network connections cannot be trusted, which as a matter of policy I don't quite understand because that's what VPNs are for. He accesses the computer without authorization if he logs in anyway. For both clauses, determining whether the gates are up or down requires considering the circumstances that cause the gates to move. I think we're losing the analogy somewhere along the line. In fact, my reading harmonizes both clauses with established concept property law. Yes, it does do that. I agree it does do that. You are, in fact, harmonizing both clauses with established concepts of property law. I agree. But there's nothing in my humble opinion that makes that approach obvious or that it's something you're supposed to be doing. Congress, you can conclude that Congress thought that then existing property law was insufficient, which actually cuts against it, if anything. If Congress thought that then existing property law was inefficient, it somewhat suggests against that they were incorporating the ideas of property law. I mean, they might have been, but they thought that property law was insufficient. Why would the statute be necessarily incorporating something they thought was improper? Now, you could say, well, they're incorporating concepts from it, not the actual technical aspects, but there's nothing inherently obvious there. So yeah, you are doing it, and the what you're reading is permissible. It's a permissible reading, but the majority has a better reading in my view. I think you're reading more into the statutes that's there. The police department could protect information by prohibiting officers from logging in with an improper purpose. But it'd do little good if an officer logged in at the start of his shift with proper intent and then hours later conducted license searches in exchange for payment. By including both without authorization and exceeds authorization, Congress ensured protection against improper login as well as misuse after proper login. It feels a little bit like reaching for policy, which I understand because the statute's not clear. So the text, intent, it's just... I see where Thomas is going. It's just not quite selling me. Congress might have wanted to try to incorporate property law concepts in this, but the problem with that is it's completely uncabined. So that's where the majority has it slightly better. So let's take the presumption that Congress wanted to incorporate property law concepts. Okay. So then the terms of use would be the license to use the property, right? Which is a very, very complicated license. And it changes from website to website and can change at any time. So that's the problem with Thomas's approach. So it's like, okay, if you go with the property law approach, then that would mean that every website and every computer site would have the absolute right to determine under what circumstances someone could access their site. Just like someone can access property in the real world, right? And I think I commented on this time because I seem to remember making this analogy before. But if like someone's going to change their access in the real world, they're going to post notices about it. They're clear. Like, you're not going to be surprised by a change of notice. It's not like, there's some click wrap license on the front of a bar that's like, by entering this bar, you agree to these 8,000 pages of terms. There's going to be a sign that says, oh, by the way, our policies have changed. You can't wear hats anymore or something. So if the policy changed in the real world, you would know. But you never know in the online world, and they can change at any time. They might change multiple times a day. So the problem is, and if they have the right to do that, they have the right to do that. But then it means literally everyone's a felon, because there's just no way that there's no way a person could use a computer a day without violating some term of service somewhere. You show me an American using a computer for a day, and I'll show you someone who violated at least one term of service somewhere. And so basically it would make felons of us all. And the statute is not clear enough that that's what Congress wanted. So the entire predicate, and Thomas doesn't have anything to cabin it off with. So Thomas is not like, oh yeah, well, but we can cabin it by doing this. We can restrict, at least not so far. He's like, yeah, property law all the way. They can have any policies they want, and those become trespass, and they can bounce your ass, and you're a felon the minute you did it, because you were supposed to read the 8,000 terms of agreement, which can change at any time. I don't think that's what okay, so let's just go with conservative principles, in my humble opinion. I don't think the text compels that result. I don't think that was Congress's intent. I don't think as a matter of history that's what they were trying to do. I don't think as a matter of policy that's a good idea. So like every canon of construction, every rule I have, if straight text doesn't say it, not what Congress wanted, it would lead to absurd results. Congress has got to speak way more clearer if it's wanting this kind of result, because we're going deep on the train. And Thomas is like, choo-choo, MFers. And I'm like, no, I'm not on board. The majority interpretation, the criminality turns on whether there's a single exception to prohibition, also leads to awkward results. Under its reading, an employee at a credit card company who's forbidden from obtaining purchases history of clients violates the acts when he obtains that data about the ex-wife, unless the employer tells him he can obtain and transfer purchase history when an account has been flagged for potential activity. The same is true of a person who minutes before resignation deletes every file on a computer. So long as the employee could alter or obtain each file in some hypothetical circumstance, he's immune. But a person who plays a round of solitaire is criminal under the majority's reading if his employer, concerned about distraction, categorically prohibits access in games. That's not quite what the majority footnote was saying, I don't think. And it was in a footnote. So I think I'm not sure that's a proper interpretation of what the majority wrote. The majority's interpretation is especially odd when applied to other clauses in the statute. A1 it prohibits exceeding authorized access to obtain restricted data, with reason to believe such information could be used to injure the United States or to advantage any foreign nation. The term restricted data is defined all data concerning design of atomic weapons. Under the majority's reading, so long as the scientist may obtain blueprints for an atomic weapon in at least one circumstance, he'd be immune. I'm not so sure about that one either. Also, that would break many, many other laws. Many laws. Espionage would be the most obvious. It's difficult to see what force this provision has in the majority reading. Well, maybe not so much with A1, but I'm pretty sure if he has permission to access nuclear bomb information, I'm guessing he's going to be in violation of the Espionage Act. So I'm not sure that Computer Fraud and Abuse Act is necessarily his immediate problem. Were there any remaining doubt about which interpretation better fits, the defined term sells it. When a definition is susceptible to more than one reading, the one that best matches the plain meaning controls. That is because there's a presumption against reading a provision contrary to the ordinary meaning the term provides. The majority instead resolves supposed ambiguity in the definition against plain meaning. It adopts a favored interpretation of the definition and then asks where a defined term can be interpreted in a way consistent with its favored view. But it should take the strongest evidence to make us believe Congress has defined a term in a manner repugnant to its ordinary sense. I didn't see the majority really doing that. The majority identifies no such evidence. The most it says is that my reading of exceeds authorized access is not necessarily best because access can have technical meanings. But whatever access might have, authority, like entailed, is circumstance dependent. The majority's reading of access confirms the point. The definition the majority cites not mere entry, but using. That accords with the definition here. Here is other contexts in property law, which I'm not so sure about. A person's authority to use his access to property is circumstance dependent. The majority focuses on the term access at the expense of authority. What the text and established concepts of property law make clear, statutory history reinforces. So he's going to go to history of the statutory text, which is not a very Thomasy thing to do. Let me go to statutory history? Not very Thomasy, but okay. The original text of this act expressly prohibits accessing a computer with authorization, then using the opportunity to access for a purpose which authorization does not extend. The majority does not deny that you're reading a lot into that. Instead, it notes that Congress amended the text in A6 to the present definition and says that courts can presume Congress' decision to omit the term purpose necessarily eliminate any prohibition for an improper purpose. Yeah. The majority cannot so easily evade history. True, the statute previously included the term purpose, and now does not, which would suggest that Congress didn't want that anymore. But the majority fails to consider how that change affected the statute. Well, presumably the word purpose, like every word in a statute, meant something. And the statute no longer means that because it no longer has the word. Often, deleting a word expands rather than constricts the scope of a provision. Sure. If a city changes a sign apart from no unleashed dogs to no dogs, no one would presume that unleashed are now allowed. If it's an adjective relating to dogs, sure. The same is true when the specific is replaced by the general. No dogs to no pets. Congress changed the statute, similarly broadened the law. The original text prohibited accessing a computer with authorization, then using the opportunity such access provides for purposes which the authorization does not extend. The term purpose limited the clause to purpose-based constraints. It did not naturally include other constraints, such as time and manner restrictions. By replacing the specific term purpose with the broader not entitled, Congress gave force to other kinds of its constraints. No, because purpose kind of goes to intent, and not entitled goes to more of a factual-based claim. So I'm not sure about that one either. Consider the previous example of the employee who violates an instruction not to log in while in an unfriendly country with an insecure network. The original text would not cover him. Possibly, that's true. The newer text would cover him. Yeah. Mithrin Emrys, nice to have you here. For $4.99, Thomas wrote this dissent. It isn't as organized, neat, and direct as usual. He needs to have his words whichever law clerk did this. Yeah, it's not quite selling me. It's not quite selling me. The majority ends with policy arguments, although I kind of think some of your arguments have been policy-based, to be quite honest. It suggests they're not needed, which, they're not. Yeah, it stresses them at length. I wouldn't say it stresses them at length. Regardless, the reliance on policy arguments is an error. Not really, because especially in the context of criminal law, like the majority kind of waved off the rule of lenity, which I'm not quite sure why they did, because the rule of lenity was perfectly able for this. Like in the interest in a criminal statute, doubt should be, yeah. Here's the rule. Yeah, criminal statute should be narrowly construed, and any ambiguity should be given to the defendant. That's the rule of lenity, right? Basically. So the majority, for some reason, said, the rule of lenity isn't a thing. We don't need it. But I'm like, okay, but the rule of lenity gives you what you need, right? It's a criminal statute. It clearly is. It's ambiguous. Let's narrowly construe it, not broadly construe it. That's a common rule in criminal statutes. There's criminal laws to be narrowly construed, because we only want to criminalize what was made criminal, not more. So if we're construing it narrowly, and we have two potential interpretations that are within the bounds, we have some more narrow and we have some broader ones, the narrow ones should win. The rule of lenity suggests give it to the defendant. Give the ambiguity to the defendant. So, I mean, if you think that's a policy argument, then okay, but I'm like, well, that's rule of lenity, which the majority for some reason poo-pooed, but I'm over here like, okay, well, I'm going to apply it. Works for me. All else being equal, the policy is let's give this one to the defendant. That's policy as deep as it goes, man. Concerned about criminalizing a breathtaking amount of commonplace activity, the majority says the way people use computer today underscores the implausibility. But statutes are read according to their ordinary meaning of the time. Yes, they are. But the ordinary meaning here does not cut as clean as I think you think it does. The majority's reliance on modern-day use of computers to determine what was plausible in the 80s wrongly assumes Congress in the 80s was aware of how computers would be used today. Not quite sure what to make of that. If the way technology has developed has exposed increased criminal liability in a way that's not clear, then it's not exactly that you're interpreting the words in the modern sense, but you're saying, well, Congress, in its intent and meaning, wasn't, it obviously wasn't thinking about it one way or another. It wasn't thinking about it one way or another, because it had no concept of the web or concept of terms of service agreement. It had no concept of any of these things. So it definitely wasn't contemplating it. The words probably doesn't mean anything like that. How could it? And then you're like, well, okay, if Congress, the words can't possibly mean that, which way does that cut? Doesn't that sort of cut the other way? If Congress, whatever they wrote, can't possibly go to the World Wide Web, can't possibly extend the term of service, can't possibly extend to that kind of stuff, then the majority saying, right, so that's not what the words mean, so they must be excluded from the scope of the statute, because Congress didn't mean that. How could they? And the statute is not written in such a way that's so clear that or it's not even really written that clear, and even not, I say so clear, like it's clear to some degree. And this domain, I don't think it's particularly obvious. Tabby's daddy says, I don't interpret another man's word. Let me talk to the man that wrote the words. Well, you understand that if you talk to the man that wrote the words, you'd still have to interpret his words. You'd have to interpret the words he's speaking to you. You can't avoid interpretation. You're interpreting the words I'm saying to you. Hopefully my meaning is being conveyed sufficiently clearly, but you're still having to interpret it. And with 103 people watching, I think the probability that there's some divergence in the understanding of my words is not wholly improper, because everyone has to interpret words. Yeah, for that matter, I have to interpret the words that you're writing. So, you know. I would also not readily assume my interpretation would automatically cover so much conduct. Many provisions narrow the statute. For example, a statute includes the mens rea that intentionally exceeds authorized access. The statute may not apply if he believes he's allowed to use the computer in a certain way because the behavior is common and tolerated. I wouldn't want to go into court with that. The concern also, I could, but it's not my preference. The act also concerns only obtaining or altering information in the computer, not using the information to check sports scores. It simply faults the government for not arguing the point more forcefully. I not give so much weight to the hypothetical concern government might start charging. I'm not sure it's that hypothetical. The majority's argument also proves too much. Much of the federal code criminalizes common activity. When it's clear, sure. Absent aggravating factors, the penalty for violating the act is a misdemeanor. Yeah, but finding aggravation isn't that hard. The act that penalizes misrunners, offenders, about as harshly as federal law punishes a person who removes a single grain of sand from the National Mall, breaks a lamp in the government building, or permits a horse to eat grass on federal land. The number of federal laws and regulations that trigger criminal penalties may be high as several 100,000. It's understandable to be uncomfortable, but the government does not give us the authority to alter. In the end, the act may or may not cover a wide array of conduct, but text make one thing clear. I'm not so sure about that. So I think I'm sold on the majority's opinion. I think Thomas's opinion is a little weak, and it's not. Yeah, I'm with the majority. The majority's opinion is consistent with the text. It makes sense. It's textually sound. Congress probably didn't intend this. Horrible result, because how could they? They couldn't contemplate it. Not really sure what that entire premise of we should read property law into this domain, yo. Not entirely sure about that. Your attempt at cabining it isn't making me feel much better about this immensely scope thing that Congress apparently did that's making us all felons all the time. They made us felons 100 other ways, but yeah. Yeah. So that's what I think, man. I think the majority has it better. It's close, but I think the majority has it better. So there we go. All right, I'm going to Gorsuch is on board, so it's safe to say it's textually sound. There you go, yeah. And Thomas is a bit old cranky. So yeah. I think it's fine. It works for me. And I did have to work on that footnote to understand what it meant, but I think I finally got there. So, all that good stuff. All right, I'm going to sign off as always. If you're enjoying this legal education content, please remember to hit the like button. Also, hit the notification bell if you haven't already done that, because, YouTube. And you can join for 99 cents by hitting the subscribe button or hitting the join button. I've been Uncivil Law. I hope all is well. Till later. Cheers and good night.